But today I'm titling it, Dear LA County, I'm suing you. All right, so the reason why I'm doing this is because when you first file a lawsuit, and I did cover this in previous podcast episodes, the first thing you have to do is file a notice of claim for damages. And you have to file it with the county and with the County Board of Supervisors. That's how you do it in Los Angeles County. You got to check in your other jurisdictions how it all works. But that's how it works here. You have to do a notice of claim, and then you have to wait for a response back from the county. So that's what I got. In fact, I got two letters from Mr. DeWin R. Harrison, acting county counsel. I don't know if you guys can see that. All right. And then I got another one. Aw, we're becoming pen pals. All right, so I got another one. So what they did is they took my claim and they said, okay, man, you have passed the statute of limitations for filing a claim. Now you got to remember, in my claim, I'm saying Judge Tamara Hall issued orders to kidnap my child from a foreign country. No mention of my actual claim or the validity of it. It's just, oh, ma'am, you have passed the statute of limitations. Well, of course, then they say, oh, you know what, though? Subject to certain exceptions, you have only 6 months from the date this notice was personally delivered or deposited in the mail to file a court action on this claim. See Government Code Section 945.6. This time limitation applies only to causes of action for which Government Code Sections 900 to 915.4 require you to present a claim. So it appears that there are, there are causes of action where you don't need to at all. It says other causes of action, including those arising under federal law, may have different time limitations. So I wrote a letter, and I'm going to read it to you guys now. They also said that, in special circumstances, that I could also, that I also could request to file a late claim. Okay. So as if I have to ask them permission to sue. I don't know, kind of weird. But that doesn't apply to me. So I'm sharing the screen here. I want to show you guys what I have. Maybe make it a little bit bigger. See, maybe, yeah, here we go. So I wrote him a letter. I should put the date on it. November 9th. Anyway, I said, Dear DeWin R. Harrison, I hope this finds you well. Thank you for your letters dated July 21st, 2022 and September 13th, 2022. I am filing a federal civil rights claim against LA County under the Alien Tort Claims Act, 28 U.S. Code Section 1350, which provides the district court shall have original jurisdiction of any civil action by an alien, I'm an alien, for a tort only committed in violation of the law of nations or a treaty of the United States. The statute of limitations is 10 years. And there's a very good argument that this claim falls under the category of international tort claims where the statute of limitations doesn't apply. The county has been made very well aware of my son's international kidnapping and has deliberately turned a blind eye, presumably because they want to run out the statute of limitations for every single shameful deprivation of rights they have continued to inflict on me and my son all of these years. There is no statute of limitations for international kidnapping under color of law, and this is a crime in progress, happening on the county's watch, that the powers that be are deliberately refusing to do anything about. The statute of limitations hasn't even begun due to equitable tolling. The irreparable harm still continues even 7.5 years later. I appreciate you took the time to write me this response. Under the circumstances, it is my understanding that a request to file a late claim is moot. Please let me know if the county agrees that a request to file a late claim is moot, and if the county accepts my notice of claim for damages and has any interest in settling this matter out of court. All my best. Because that is the whole point of doing a notice of claim. It's like any other lawsuit. You have to start off with a what's it called? A demand letter where you're saying, look, this is what you did, and you need to remedy this. Otherwise, I will be forced to take further action as permitted by law, something like that. You can't say, I'm going to sue you, but you have to kind of say, let's talk. There's no threatening involved. It just has to be like that. So I've heard of a case where LA County actually settled with a mother who they screwed over, violated her civil rights, and they actually offered her $150,000. It didn't get her kids back, but in that particular case, I don't know the whole situation, what that specific thing that she was suing for, but they actually decided, oh, no, okay, here's, I also read somewhere that every county council that gets one of, our complaints, they actually have the authority themselves to decide whether they want to, just up to $20,000, they have the, they can actually make, without having to talk to their supervisors, they can actually try to settle the case. I'm just doing this because this is kind of what you have to do. It's the procedure, right? And who knows? Maybe they're like, oh, you know what? Maybe there will be some negotiation back and forth. Who knows? Maybe they know that they fucked up. Maybe, well, of course they know they did. But this case is pretty open and shut. So, if I go to federal court and I can find an attorney that has, all they really need to do is just show up for me. Because of course I will do all of the work and I'll organize absolutely everything. I don't want to sue pro se because obviously they don't take pro se litigants very seriously at all. So I will start off pro se and see how far I get. And then I just hope that a civil rights attorney will jump in. I am actively seeking a civil rights attorney outside of the state. Hopefully, because then, you don't even know anybody in the state. It is federal. So you could just, I think it's, they have to file some sort of a request with the state bar in order to be able to step in and, get permission to do that. Yeah, so that's the next step. I got to send this off tomorrow, and then I'm going to be curious to see what they do. So according to them, I have 6 months to present a claim, which means they filed this just July 21st, and I believe I'm going to look at my calendar here because I did the math. So it must be January, right? Because it's 6 months. So it must be January 20th before I have to do this. I'm still working on it. This is a very short video. This week has been very, very emotional for me. I kind of had a bit of a, I don't know, like some kind of a spiritual awakening or something just because I had to break down and kind of process everything that's been going on because I've been suffering for so long. Like one month, as you see my eye, I was crying so badly. Yeah, I really have to process all of this. The fact that I get to see my son in less than 7 days, And it's the first time in 7.5 years. And even my son right now, he doesn't want to talk today. I could see it in his eyes. He was so completely depressed. And I think it's like me, I've been feeling kind of in a fog and stuff, because it's just unbelievable to think that just how much power one person has had over our lives. And how easy it is for them to just stop and allow us to see each other. So it's all pretty sick. I mean, I'm super excited and super happy, of course, but there's also that at the same time, this you have to face it, that like, this is abuse. We've been abused, like fully, emotionally, because one person decided that we can't see each other. And unfortunately, they had the county of Los Angeles pull out all the stops to make sure that he got what he wanted. So he still has sole legal and physical custody. And I told him 6 months ago, you can keep it. Give a fuck about the actual paper, because really, guys, it's just a piece of paper. He can keep his piece of paper. All I need is a letter, travel letter. You can keep all of that power, all of that. Just don't worry about it. It's yours. I won't even fight for it. But you have to let me see my son. And I told him that like 6 months ago. And then finally, like a few weeks ago, he just sent me this random text message saying, hey, what do you think about us not trying to throw each other in jail, and maybe trying to, work things out so that you can come and visit on the condition that you just won't take me to court anymore. And of course I took him up on it. Like, life is short. I've missed so many years of my son's life. Like, I'm not going to miss another second. So that's where I'm at. If you don't know anything about my story before, I should have said it in the beginning, but essentially, I'm suing a California judge for kidnapping my son under color of law. She issued orders in chambers without notice for that opportunity to be heard, when neither party were present, when both parties and the minor child were living right here in Vancouver, British Columbia, Canada. There was no court reporter present. There is no transcript. Somehow, some bizarre situation happened, and something came across her desk and she signed it. And she literally, in her own scribbled handwriting, said, essentially, issued an order to seize my son from Canada. There isn't a judge on the planet that has the authority to seize a child from a foreign country. If the child is in your jurisdiction, you absolutely have the authority to order, if both parties can't agree, you can order the, issue in a move away order, or, in the case of an international kidnapping case, the judge where the child has been kidnapped to, they have the absolute authority. Like LA County has the authority to issue orders to return my child. And I'm suing LA County because they've known this whole time. I mean, fully aware of it. So I'm asking also for punitive damages, because I want to make sure that this policy of covering up crimes for other, just to avoid lawsuits, has to stop. And I'm really truly hoping that LA County will end up deciding that, making it a policy, just like they changed the laws and everything else in the right to lie case, Hardwick versus Freakin from Orange County, where the court decided, you know what, social workers that lie, first of all, they're not allowed to lie. And secondly, the county won't defend them. You know what I mean? They don't have immunity for lying. I guess that's what I'm trying to say. That's properly what I should say. And then, of course, they don't have to actually uh, they don't have to represent somebody. In fact, they really shouldn't ethically represent somebody who absolutely did lie to take away someone's child. In this case, it's even more serious because it's a judge who did something, who acted outside the territorial jurisdiction of the United States. And that has never been done before. So, and everybody knows, like all the other judges know, and somehow, some way, they have run interference and have covered up this crime. And they can cover it up because they all have the cloak of judicial immunity. So what I'm going to ask is somehow asking for relief. I don't know if it's injunctive or declaratory, whatever it's called, but there's a way of asking for relief to change the policy, like to say, okay, this can't happen again. And that's what I desperately want. I want to make sure that everybody, you know, if you have absolute immunity and you find out that someone else with absolute immunity has possibly committed a crime or absolutely committed a crime, it doesn't matter. You're not the jury. You're not the investigator. But if you have absolute immunity and you become aware of someone else, another judge, let's say you're a judge and there's another judge, or you're a prosecutor and there's a judge that you know absolutely are quite certain that they committed a crime under color of law, they should report it to federal law enforcement and stay on it and be willing to testify as a witness. And actually, it's their duty to like play it out to the very end and find out exactly how this is going to be handled. Otherwise, if they don't do the right thing, if they commit misprision of felony, which is just when they see they're witnessing a crime, but they're just deciding to do nothing about it, or even worse, deciding to cover it up, right? And abuse their own authority to kind of cover it up for their buddy, that they would be considered an accessory after the fact. Or even before, because if they knew something was going to happen beforehand and they just like kept their mouth shut, then yeah, you are just as guilty of the crime as the person, you know, as the person who committed it. It's kind of like there could be an armed robbery. And there's only one person that has a gun and pulls the trigger, but everybody will be found equally guilty of armed robbery or even murder for that matter. So kidnapping is no different. It is a very, very, very serious federal crime. And to think that a judge actually did this and the county just said, oh, okay, that can't happen anymore. So I believe that the best way to handle it is to make sure that everybody with absolute immunity recognizes that if they abuse their authority and don't report a crime, no matter how insignificant or serious, that they lose their absolute immunity. I think that's only fair. And I think that would make it so that the entire culture would change in the courthouse, because people would go, I'm not going down for you. Are you fucking kidding me? No way. I have, you know. So then all of a sudden they're there to save their own skin, you know. That's what I'm hoping for. So that you know, so that all of this corruption in court, where people are deprived of their rights and their children are stolen, and it's all like just a big game that the attorneys are playing to just rob everybody blind. That hopefully that will come to as I like to say, a screeching halt. Anyway, that's it for today. It's a really short video. I should make my videos shorter anyway. So this is nice practice. But I won't see you guys next week because I'm going to be in Los Angeles with my son. So anyways, thanks for being here, and I will see you